Is there anything more frustrating than a washing machine that just decides to quit on you? 1 minute it's humming along, the next, silence, or worse, a puddle on the floor. Or that awful burning smell. We've all been there, staring at a pile of dirty laundry and a very expensive, very large paperweight. It's infuriating, right? You spend hundreds, sometimes thousands of pounds on an essential appliance, and you expect it to last. But what happens when it doesn't? What are your actual rights when your brand new, or even not so new, washing machine or washer-dryer breaks down? Stick around, because today we're diving deep into UK consumer law, and I'm going to arm you with the knowledge you need to get the refund, repair, or replacement you are legally entitled to. You are more powerful than you think. First, let's talk about the common culprits. We're looking at things like mysterious leaks that suddenly appear, turning your kitchen into a paddling pool, or the drum just refusing to spin, maybe making a horrible grinding noise like it's chewing on rocks. And then there's the scary one, the electrics burning out. You might see a flash, smell that distinct, acrid plastic smell, and that's it. Game over. These aren't just minor inconveniences. They can be serious, sometimes even dangerous, faults. Now, who are we dealing with here? This is crucial. The law we're talking about, the Consumer Rights Act 2015, protects you when you buy from a retailer. That means big names like Currys, AO.com, Argos, John Lewis, and other high street or online stores. This law applies to them. However, it's important to know it does not apply if you bought your machine from a private seller, say, off Facebook Marketplace from an individual. The exception is if that private seller is actually a business seller masquerading as an individual. The law still covers you there. But for a genuine, one-off private sale, it's buyer beware. So, for today, we're focusing on purchases from retailers. The hero of our story is the Consumer Rights Act 2015. This piece of legislation is your best friend when goods you've bought are faulty. It lays out what you're entitled to and when. It replaced a bunch of older laws and made things much clearer. At its core, the Act says that goods must be of satisfactory quality, fit for purpose, and as described. Let's break that down. Satisfactory quality means the machine should work properly and be free from defects. A brand new washing machine that leaks is clearly not of satisfactory quality. Fit for purpose means it must do the job you expect it to do. A washing machine that doesn't wash clothes isn't fit for purpose, and as described means it must match the description given to you by the retailer or on the box. So, your machine is faulty. What's the first and most powerful tool you have? It's the 30-day right to reject. This is a game changer. If your washing machine develops a fault within the first 30 days of you taking ownership, you are legally entitled to a full refund. No arguments, no credit notes, a full refund. The retailer might try to offer you a repair or a replacement, and you can choose to accept that if you want. But the choice is yours. They cannot force you to accept a repair if you are within that 30-day window and you want your money back. To exercise this right, you must contact the retailer, that's the company you paid, not the manufacturer, and clearly state that you are rejecting the goods under the Consumer Rights Act 2015 as they are not of satisfactory quality and you want a full refund. Okay. But what if the fault appears after 30 days? Don't worry, you're still protected. After the 30-day mark, and up to 6 months, the power dynamic is still very much in your favor. If a fault develops during this period, the law presumes that the fault was present at the time of delivery. This is called the reverse burden of proof. It means it's up to the retailer to prove the machine wasn't faulty when you bought it, which is incredibly difficult for them to do. In this situation, the retailer has one opportunity to repair or replace the faulty appliance. They must do this at no cost to you, within a reasonable time, and without causing you significant inconvenience. Which one do they choose, repair or replacement? Well, it has to be your choice, unless one of the options is impossible or disproportionately expensive for the retailer compared to the other. For example, if a simple repair can be done quickly by an engineer, they might push for that. But if the machine is a total write-off, a replacement is the logical step. The key here is that they only get one shot. If their attempted repair fails, or if the replacement machine is also faulty, you are then entitled to a full refund. Let's be clear about this. One failed repair is all it takes. You don't have to put up with engineer after engineer coming to your house, trying different things while your laundry pile grows to the ceiling. If that first repair doesn't fix the problem permanently, you can go back to the retailer and say, "You've had your chance to repair it. It's still not working. I now want a full refund." Now, what if we're beyond the 6-month mark? Your rights don't just disappear. The Consumer Rights Act 2015 says that goods should last a reasonable amount of time. In the UK, it's generally accepted that a major appliance like a washing machine should last for at least 5 to 6 years. Maybe even longer, depending on the price and model. So, if your machine develops a major fault after, say, 18 months or 2 years, you are still protected. The only difference is that after 6 months, the reverse burden of proof flips. Now, the onus is on you to show that the fault was inherent, meaning it was a problem with the manufacturing or materials, and not due to misuse, accidental damage, or simple wear and tear. This might sound daunting, but it's often easier than you think. How do you prove it? Well, you could get an independent engineer's report. You'd have to pay for this initially, but if the report confirms a manufacturing defect, you can claim that cost back from the retailer along with the cost of the repair or a partial refund. Often, the nature of the fault itself is evidence. For example, a main control board burning out after 2 years of normal use is highly indicative of an inherent fault, not misuse. So, you've got your facts straight, you know your rights. Now, it's time for action. What's the process? Step 1 is always to contact the retailer's customer service. Be calm, polite, but firm. State the problem clearly, and tell them what you want. Say things like, "My washing machine, order number 12,345, has developed a major fault. As I am within the first 30 days, I am exercising my short-term right to reject under the Consumer Rights Act 2015, and I require a full refund." Or, "My washer-dryer is 7 months old and the drum has failed. Under the Consumer Rights Act, I am requesting a repair or replacement at your cost." And this is the part where things can sometimes go wrong. What if the retailer refuses? What if they tell you to contact the manufacturer? This is a common and incorrect tactic. Your contract is with the retailer, the company that took your money. It is their legal responsibility to sort this out, not the manufacturer's. The manufacturer's warranty is a separate thing, an extra layer of protection, but it does not replace your statutory rights with the retailer. So, if they refuse, or fob you off, it's time to escalate. Ask to speak to a manager. If that doesn't work, you need to put it in writing. Send a formal email or letter. This creates a paper trail which is incredibly important. In this letter, you should state the facts of the case, reference the specific parts of the Consumer Rights Act 2015, and give them a deadline to resolve the issue. 14 days is usually reasonable. And here's a powerful phrase to include in your letter if they are refusing your rights. I am putting you on notice that if you fail to provide a remedy in accordance with my statutory rights, I will begin a claim against you in the small claims court to recover my losses. My claim will be made under Section 9 of the Consumer Rights Act 2015. Section 9 is the part of the Act that covers satisfactory quality. Citing the specific legislation shows them you've done your homework and you are serious. This often gets a very quick and positive response because the last thing a big retailer wants is to deal with a small claims court case that they are likely to lose. If even that doesn't work, don't give up. Your final steps could be to use a dispute resolution service if the retailer is part of one, or to actually file a claim through the government's money claim online service for the small claims court. It's a straightforward online process, and the fees are relatively low, and you can claim them back if you win. Let's recap the key takeaways. Your contract is with the retailer, not the manufacturer. Within 30 days, you have an absolute right to a full refund for a faulty machine. From 30 days to 6 months, the retailer has one chance to repair or replace a faulty item before you can demand a refund. After 6 months, you're still protected for a reasonable amount of time, but you may need to show the fault was inherent. Always be polite but firm. Put everything in writing. And do not be afraid to mention the Consumer Rights Act 2015 and the Small Claims Court if they refuse to help. Knowing your rights empowers you. It turns a stressful, frustrating situation into a manageable process where you are in control. Don't let a faulty appliance ruin your day or your bank balance. Use the law that is there to protect you. I hope this guide has been helpful. If it has, please give this video a thumbs up and consider subscribing for more consumer rights tips. Thanks for watching.